Cherry, can I have parties announced?
Yes, please.
Warren Wolf for Ms. Cherry.
And are you Ms. Cherry?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Krista Colleen Cherry who's placed on deferred adjudication in 2022 CR 6941 for the offense of assault of a public servant on January 30th, 2023 for a period of 2 years and extended for 1 year? Is that you?
Yes, ma'am.
All right, state you may proceed.
Violated condition number 4 in Bexar County, Texas. The defendant, Crystal Colleen Cherry, did then and there fail to report to the supervision officer as directed for the months of September, October 2025 in violation of condition number 2.
How do you plead to that, true or not true?
Civil waiver.
And revoke you and sentence you up to 10 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, please.
Court will find violation of condition number 4 true. Is there a proposed agreement or recommendation from the court? All right, state, what are you requesting?
Requesting revocation, Your Honor, and sentencing of 3 years.
All right, in defense, what are you requesting?
We'd ask that you follow the recommendation of probation.
Whoa, hold up, did you catch that? She's being told she could face up to 10 years in prison for violating probation. But here's the twist. This isn't her first motion to revoke, which means the court has already been lenient before. Let's break it down. Deferred adjudication allows her to avoid a formal conviction if she follows probation rules, but repeated violations stack up fast. Ask yourself, would you risk a decade behind bars for missing a few check-ins?
Question, this is not her first motion to revoke, and it's for the same issue.
Understood, and I see that, but she did not get the services that are being recommended now. She's been through quite a bit, and she really, it's a tough situation, and I'd like for her to explain to you why she was unable to report.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Crystal Colleen Cherry.
All right, so this is not your first motion to revoke. You've been here before for not reporting, and that was January 2024. And the court denied the motion, altered and amended your...
Okay, this is getting intense. She's now under oath, explaining her side, and there's a lot on the line. Medications, children taken by CPS, mental health issues. The audience can feel the weight of it all. The court has to decide not just if she broke rules, but if she's mentally and emotionally competent to be held accountable. You gotta ask yourself, can personal trauma ever truly excuse legal violations?
Have you talked to probation?
I told him everything. Bruh. I went to Vegas for a cold. So
All right, so
get on the website.
It was at this moment that she knew. She fucked up.
let me stop you right there. This is what we're gonna do. Probation,
Yes, Judge.
can you look and see if she's ever had any contact with probation by phone or email, if there's no objection? By phone or email since...
She was reporting, and what happened was during this
Just
period
one
of time.
second.
And here it is. The moment you can almost feel the tension snap. She realizes she really messed up. The judge pauses. The room goes quiet. And the audience can sense that this is a turning point in her case. This is classic courtroom drama. One moment, everything seems manageable, and the next, the consequences loom large. You can almost hear the audience whispering, how did it get this far?
I'm gonna have you take a seat. Your attorney will be able to speak with probation, and the state will be able to see if they have anything in the system.
Yes, ma'am.
Because it should be in the system, okay?
Yes.
All right, thank you.
2 very boring minutes later.
We're back on the record in Crystal Cherry. Any objection to the court going out of order so I can take testimony from Ms. Abrams, or just receive an update from Ms. Abrams?
Sure, no problem.
Yes, Ms. Abrams.
Judge, the last face-to-face meeting and office visit was done on August the 25th.
Okay.
After that, there was due diligence done with calling Haven for Hope. We received information she was no longer there. We called it a couple of other places. We received information that she was discharged from the Genesis program with the Center for Healthcare Services because of her absconding as well.
But you do
I have
confirm the fact that
825 was the last office visit.
she did have contact?
All right, any objection to the court reviewing the violation report?
No.
And Judge, I did also, I have the court summary if you'd like to review that as well.
Any objection to the court reviewing the court summary? All right, so I'm going to tell you what I have in the violation report. In the violation report, it states that you were at Cross Point and you moved out of Cross Point.
Yes, ma'am. And I was staying at a friend's house, but
No. Here's the thing. You're not allowed to move from place to place. When you're on probation, your residence has to be approved by probation. So you left
and I did
Cross Point.
I did let my probation know where I was.
But no. That's not how probation works. You can't just go wherever you want to go.
Yes, ma'am.
So you left Cross Point.
Yes, ma'am.
And then you went for Haven for Hope. And you're telling me now between Cross Point and Haven for Hope, you ended up staying at some friend's house.
I was staying at my friend's house, and then they kicked me out, so I went to him for Hope, and that's where I was staying.
Well, you're not supposed to leave Cross Point.
I didn't know that. I'm so sorry.
Yeah. All right.
I didn't know the rule.
Here's a key legal breakdown for everyone watching. When you're on probation, you can't just move from place to place without approval. Leaving Cross Point, staying with friends, then going to another facility without notification isn't a minor slip-up. It's a direct violation of her supervision conditions. The court isn't just frustrated. They're pointing out a pattern of disregard for rules, and it's a major factor in sentencing. Did you notice how something seemingly small snowballed into a huge problem?
All of the issues that your attorney is requesting that I give you to address your failure to report, that's already been done before. And you're back here with the same thing, failure to report. I can't help you, and nobody can help you if you won't follow through. And for you to leave Cross Point without permission, that was a choice. And then from Cross Point, you leave without permission, and then you start staying with some friends. And then from there, you leave and start staying from Haven for Hope, and nobody knows where you are. And according to the violation report, they actually attempted to contact all of your collaterals that you have given them, all your family members, all of the phone numbers. So I just don't think that you're appropriate for probation.
Judge, she has a letter that she'd like to give you.
Sure. All right, any objection to the court reviewing the letter? Sorry. Oh, no.
Now the judge lays it all out. She's back with the exact same violation, failure to report, despite prior interventions and programs. This is the part where the audience sees the real stakes. Repeated non-compliance limits any chance for leniency. The court emphasizes that no one can help her if she refuses to follow the rules. And that's a hard truth. This is the moment where her fate hangs in the balance. And you can't help but ask, will probation ever be enough, or is prison inevitable?
That she was sent to the duly diagnosed residential facility, and she was there from 1/23/25 to 6/3/25.
Oh, she was
spent 133 days there, and she completed that program. So my point is that when being supervised in a residential program, she was successful. Under classes and other conditions, on 5/2/23, she was evaluated TAP substance abuse, and she completed the program or term there. In addition, it has on the bottom sober support meetings. She was going to those meetings, evaluation TAP date from 1/30/23 to 8/23 24, 8/23/24, completion of the program or term. So she has a history of some success under the supervision of the court. And I'm looking at the recommendation of probation here, and it says to extend her and put her in a state ISF cognitive program, that the state IS will be to help her with correct thinking, promote social behaviors, and in a drug-free zone. One of her concerns is she's been explaining to me that she's experienced issues with CPS taking her children. They took them up to Oklahoma, and that's difficult for anybody. And
Now,
someone with her condition, she's on several medications right now. She's taking
That's right, so, and, pepper. I have seizures.
all right, so this is what I want you to understand. One, I understand your attorney's argument, and I understand your argument. However, this is the second time you've been before the court on a violation of condition number 4, which is not reporting. And with that violation of condition number 4, what your attorney is telling me is similar to the information that I received before. And so what I did was I had them give you a place to stay, which was Cross Point. You left Cross Point.
That's right.
You decided to go with some friends. And then you're saying they put you out.
Then you went into my card. I have 3 checks coming in check card. I put a lock on it because they changed on my phone, used my pen lock on my phone to change it to their.
Let me ask you this. Did you have your children with you at Cross Point? Or were they with CPS?
CPS took them
All
away.
right, so CPS had your children while you were at Cross Point. You leave Cross Point and go live with some friends. And you said the friends were stealing the child support money, right?
Not just for my Social Security,
Okay,
my SSI, my SDI.
all right.
I'm on discipline check.
All right, so what I can tell you is this. I've tried to give you conditions to help you. And if you had a CPS case, CPS would have given you conditions to help you.
They were all close. My 2 oldest was never terminated. I have temporary custody. And then my last one, my youngest daughter, was terminated.
So this is what I'm going to do. I'm going to grant the motion, find you guilty, revoke, sentence you to 3 years in the prison, give you credit for any time served, credit for any successful completion of inpatient treatment, and I'm going to request the therapeutic community. All right, we can go off the record. So here's the thing. The therapeutic community is designed to help you.
Yes, sir.
I have no jurisdiction to force them to place you in the program, but what will end up happening is on your judgment, it'll show that the court is requesting that, but you're going to have to ask for that as well.
But I have to go back to the housing.
Now, once you've been released from the prison, if you make parole,
I'll have 3 years in prison.
Finally, the sentencing and therapeutic program explanation lands. The court requests placement in a therapeutic community designed to help with corrective thinking and social behavior, but legally, they can't force it. This part is fascinating because it shows the difference between legal authority and rehabilitative intent. She could serve 3 years but still benefit from programs if she actively requests them. For the audience, it's a reminder. The legal system isn't just punishment. There are pathways to recovery, but only if you follow the rules.